Welcome to the Cook Group's podcast, What's Cooking in Litigation, with your host, Brian Wacker. In each episode, you'll meet industry leaders, innovators, and educators in litigation. We'll discuss the latest advancements, efficient practices, and strategic updates. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Now here's the host of What's Cooking in Litigation, Brian Wacker.
Hello, and welcome back to What's Cooking in Litigation. I am your host, Brian Wacker. Each week we have been going basically around the country in our law firm to talk to what we think are some of the sharpest minds in the industry, talking about latest trends in litigation. And this week we are circling back to our New York office to talk to one of our founding partners, Gary Casimir, who happens to be one of the most interesting men that I've ever met. He's got one of the great background we're going to jump into. So
now, Brian, you're coming off like a little liar on national, whatever this is, national podcast. The most interesting man I've ever met.
Well, within the firm, at least. How about that? We can narrow it down a bit because that'll.
I'm trying to remember the guy. Was it the Modelo commercial?
Yeah, something like that. Yeah.
The most interesting man in the world.
That's right.
I wish I was him.
Well, thanks for joining us. We appreciate the time. I got a lot to talk about, and I know we don't have all the time in the world. But first off, before we even get into your practice and what you're doing now, I'd like to just ask you a bit more about your background. You were born and raised in Brooklyn, I just heard.
Yes, I was. I'm still very connected to Brooklyn in so many different ways. I still have a place out there in the neighborhood I grew up in Park Slope, Brooklyn. And no matter how long I've been in the suburbs out here in New York, I can't. When people ask me where I'm from, I still say Brooklyn, even though I'm raising my kid out in the suburbs for the last 20 years or something like that. So it's hard to give up that moniker. Right.
And you're actually, if I remember correctly, you're a bit of a small business owner outside the firm as well in Brooklyn too, right?
That's right. I have a restaurant in Brooklyn that I've been operating. We're going into our 10th year now since I opened, which for New York City is a marvel in and of itself. I don't even understand how it keeps going. But I guess I'm blessed in so many different ways, and are cursed. One or the other. If you look at my weekend schedule and what my wife says about, I don't spend enough time at home and worry about the kitchen too much. But
yeah,
I am lucky that way. It is a completely different world from where I guess my education took me. A little bit about my background, I guess. I started my legal career as an investigator for the Homicide Bureau in Brooklyn at Kings County District Attorney's Office. And that was after college. I did homicide investigation, mostly witness interviews, observation protections, that kind of thing. And then, as well as police, going out and looking for witnesses with police officers. And then from there, I went to law school in Boston. I left Brooklyn and went to school in Boston, left New York, which is where I went to college as well. And Boston was a great experience for me. And when I came back to the DA's office again, and I got the opportunity to be a prosecutor there. I stayed 7 years as a DA in New York City. Worked, started off in criminal court, ended my career in trial bureau, homicide bureau. Did that until I left for Reed Smith and Anderson Kill. Left those two for a job on television for a little while. I did that for 2 seasons. I was on a show called Power of Attorney on Fox. That lasted 2 seasons. They forgot to tell me they were, discontinuing the show, which is how television works sometimes. But I hope it wasn't my fault. And did that, and then continued at Reed Smith, and then eventually had the opportunity to, come here and start the Cook Group with Carrie Ann and a few other people.
Yeah. See, I wasn't overstating it. I don't think there's many people who are going to have that sort of a interesting background getting into becoming a lawyer beforehand. So, I'd tell you, the folks that I talk to that work as DAs or public defenders, I don't know if at the time they look at their time there and think, oh, this is the greatest thing in the world. But I bet looking back on it now, I bet you got some great trial experience and kind of got you to this point in your career where you're still trying cases, right?
Yeah, I mean, that's all I've been doing ever since I've been in legal, I guess, in the legal field. When I left college, I was always involved. My work as an investigator at the Kings County DA's office always worked from ongoing trials that were going on. It's one of the motivations that took me to law school. And no offense to the people I used to work with, they were great people. They included people who became celebrities after the fact, including Star Jones and Brockman and a few other people that are well-known attorneys. But I also felt that I could do the job better. And that's what made me go to law school. I thought, oh, you messed that up, buddy. Imagine telling Star Jones that. But I felt that I could do it better. And it was my biggest motivation to go to law school. And when I came back out, I just wanted to do trial work. And that's all I've ever done for the last, without aging myself, a good more than 20 years. Yeah.
Well, I got to say, in terms of your work as a trial attorney, you cut your teeth in New York. It sounds like in the criminal side, and then you've been working in what we call NYCAL or New York. What does NYCAL mean? Actually, I see it all over the place.
Well, I my teeth in New York City in terms of the civil side, New York City litigation. I started in Med Mal, actually. That was my first work outside of the DA's office. I was doing medical malpractice, moved into toxic tort. I did some product liability work involving, back then it was breast implant litigation that was causing a lot of negative effects. I did that litigation for some time before moving into the world of product liability and asbestos in particular. And so that I've been doing, and that brought me to the NYCAL world for the last 25 years or 24 years. I've been actively engaged in the NYCAL litigation, or I should say asbestos litigation nationally. As a trial attorney, my work, fortunately, unfortunately, takes me to various courts in New York, Chicago, California, Philadelphia. I usually go where I'm still needed or desired in terms of trying a case. So I've had an opportunity to have some sort of a national presence, or at least multi-state trial practice that has taken me for the last, at least the last 15 years. It does take a little time to get to understand the medicine in asbestos. It is a field in and of itself, of its own. So, I mean, you could be in asbestos litigation and really not completely understand how the cases are tried and the medical medicine involved. The background in medical malpractice helped me a lot, understand a lot about the medicine, especially cancer. The way I work in breast implant litigation, taught me a lot about cancer diagnoses and mistakes that can be made and things of that nature concerning it, the genetic implications of it. Especially when it comes to breast cancer as an alternative cause. So, I have that background. NYCAL in and of itself just means New York City asbestos litigation, which is where I started to cut my teeth.
Right. Got it. Well, so one of the questions I asked for you is, a lot of the folks that are watching this are either young attorneys, folks in the industry. And I think one of the things you just hit on is very important, is that not every attorney who's involved in litigation knows exactly why they're doing any given thing at any given moment, because litigation is so complex and it lasts for so long, any given time. What are some of the things you see in your position more often coming in later at the end of a case when it's getting ready to try? What are some of the things you see that you would tell a young attorney or attorney who's just getting involved, hey, this is really what we're looking for and what we're hoping to have ready in a package for me 4, 6, 8 weeks out of trial?
I think that's a great question. I think a person like me, who's often brought in after everything is done, has had an opportunity to see some patterns of things that you don't want. Okay. I'm lucky I'm at a firm that I believe we have a lot of attorneys that are trained to understand, to get the details out. And we do a lot of preparation to make sure they're ready. But I guess so that our listeners and the non-lawyers and the lawyers who know that the details matter in the early stages, because you can't get it into evidence if you didn't check off all the boxes. And I think a lot of people think that, oh, it just comes in, or it's just naturally, oh, that doesn't make sense. Perfect example would be proof of claims, in terms of bankruptcy and conditions. And we'll talk a little bit about that. But when you ask me what are the things the pitfalls I think that anybody should be careful is not to get complacent. A lot of things we do over and over and over again, and there's a tendency to not want to be, for lack of a better word, the AO in the room who keeps you there an extra hour asking more questions than anybody thinks is necessary.
Right.
And we'll talk about this a little later when that would come into play. But in order for me, when I get the case, there's two things that might happen in our litigation. Unfortunately, the plaintiff is no longer there anymore to ask the questions, right? So you're stuck with the records you have. Then you really can't develop it anymore. Or two, it's too late to develop it from somebody else's knowledge or from other resources or from other people that are around. So it's really important that those details get fleshed out really early, and they can be, it ranges in gamut and what I'm talking about. It could be something that will lead to something else, or it could be something I could use at trial.
Mm-hmm.
And I think the most important thing is when we give those, when my office or send somebody out to ask, 1,000 questions, they may feel that questions are not necessary, and others in the room may feel like, why is he asking this? But don't worry about that. The worst thing that could have happened is you didn't ask the question, and there's nothing like that. And so you need to have that mindset when you're going out, and just don't be afraid to ask the hard questions. Don't be afraid to ask the uncomfortable question. If everybody's uncomfortable in the room, you're probably asking the right questions. That's a motto I live by a little bit. It's not easy. It squirms in your seat a little bit, but
yeah,
you probably touch you on the right nerve.
I think that is a great point with respect to young attorneys in any part of our industry, is being willing to go out there and not just take the comfortable route. Right? It's going out there and doing the hard work, not becoming, as you say, complacent, because ultimately what we're all doing matters, and it's all part of a bigger picture for each case. And that one of the bigger parts of that picture I wanted to ask you about, kind of, I guess, pushing forward, is when you do get these cases, what is it that you're seeing? I mean, you've been trying jury cases now for a few decades now. What is it you're seeing with juries, let's say particularly in New York, but elsewhere as well? What are juries caring about more these days or less these days? And what are maybe some misconceptions we may all have about what 12 people are going to say to decide, if what we're doing actually matters?
Yeah, I think, all right, so if we're going to focus on juries a little bit, we have to understand that, no matter how much we try to put this litigation and the presentation of evidence and the idea that only what we say right here in this room matters and you should listen to, jurors don't live in a vacuum. They have been around, they've lived, wherever they're living, and they're experiencing whatever's happening, in real time, especially today with, 20 years ago, you didn't have all of this information shooting out of your phone all the time, constantly. And you can Google anything and anyone, any minute. And jurors, no matter what you say, don't Google us. They've already, the moment you said that, they Googled.
What are you talking about?
What are you talking about? So it's absolutely, I think you have to come from a perspective of understanding that the jurors are smarter now, that they're more informed, or on the other side, more misinformed about things, right? And when the biggest part of the litigation that has, I think, affected us, the level, the winning. How do I want to make sure I'm saying this correctly, but the perception people have is probably what your jurors have. And you should be working from either, if your side is with the perception, then, play with that and move that ball forward. And if the perception is not on your side, it doesn't correlate with your position on something, you need to address that right away, and make sure, because they are not fools. They'll just think you're a lying sack if you're not addressing why what I'm saying is inconsistent with what you hear all the time and what you see all the time on TV and on the radio. And, you know, especially coming from the defense perspective on the civil side in products liability work. And when you're dealing with corporate clients or clients that are, large manufacturers, the jury has to have perceptions of that. So you have to deal with that. So what I've seen is, a change in juror mindset to a certain extent in terms of perception of something. There was less known to be so definitive about certain things, and we can go into detail about what products I'm talking about. But there's more of a definitive sense of that's what it is, and you could tell what that has done over time in terms of the litigation. For example, if you take toxic tort litigation, which I am involved in a lot, and which I think you're aware of as well.
Right.
If you take that into consideration, the concept of dose played a big role 20 years ago. And plaintiffs' firms, on the other side of what I do, have, in my opinion, successfully reduced the idea of dose being a factor in consideration here. And one of the ways you can see that is with regard to the talc litigation that's taking place in the nation. I mean, it was unheard of that talc cases would come to this fruition. And now it is the biggest stream of litigation that's going on. And the reason why it was not as prevalent in the past was the dose issue. It's not that there's a possibility that you could have a contaminated mine, that even if you did, the level of asbestos in any lot or a bundle, in any lot of mineral of a talc being taken out is so diminutive that to say that it got to an individual is purely, statistically quite difficult to achieve. Right. But it doesn't matter anymore because the contaminated element is so prevalently or perceived to be bad, or has to have done it, and so you're dealing with that backlash, and so it's very hard. So when you ask me, what have I seen that has changed, I think jurors have gotten, have more access to information. They've been indoctrinated into a certain argument that you have to deal with that from the forefront, and you could tell it's changed because what people are willing to go after and bring. There were certain plaintiffs' attorneys, if you had very little dosage of exposure, would be hesitant to bring the case because the dosage wasn't there. Even their own experts would admit. Right. Now they're experts. If you have the most 2 minutes of dose of exposure, they're going to take it all the way and try and demand, I think, ubers of money, not respect, not, and even though it's not consistent with the science. The dosage in science has not gone away.
Yeah. So those preconceptions or those sort of things that have become quote unquote accepted facts have sort of calcified at the beginning on the outset of this litigation. And we're the folks on this side of the V at least are going to be up against that for as long as this lasts. Is that right?
Sure. Absolutely. Yeah. And that's exactly right. I think, it has become, look, like I said before, jurors don't live in a vacuum that you put them in a room and they say, don't look at anything else. I'll give you an example. I was on trial in New York County maybe 2 years ago, and on the door walking in, there was a sign that said, warning, asbestos abatement taking place in the courthouse. And every day I'm going into the courtroom, I'm saying, Judge, I'm asking the judge, I'm not going to get a fair shake here. There's a sign on the door telling everybody, warning, danger of,
right.
And this is a warnings case,
Yeah.
I'll tell them to ignore it. I'll tell them, to put it out of their mind. They're going to do what I tell them to do, Mr. Casimir. Don't worry about that. This is my courtroom. It's not going to work.
Right.
The mention of it brings it back to their attention, but, it was on the doorway as you enter the court. As you enter the 60 Center Street. And that's the location where, Law and Order is always filmed when you go up the steps. But on the door right there is placard. So this is what I'm dealing with. So when I say it's not only even the courthouse is rigged, not necessarily in my favor when I'm taking on these toxic tort cases.
Yeah, right. Well, so you talked about talc. That was the last thing I kind of wanted to hit on is, I've mentioned this with a couple of our other partners that, for as long as I've been practicing, I've been told that asbestos litigation has a shelf life of 4, 5, 6 years, whatever it is. And we all have seen where that's gone. The talc litigation, to me at least, and everything that I read and everything that all the emails we send out, it seems like there remains some uncertainty, but it's starting to take a little more hold now, and a lot more of the law firms that you would expect to be getting involved in this on that side of the V are really starting to take on those cases. Do you see any ebbing of that, or do you think it's going to continue to expand in the
Oh no, I listen, I think you're absolutely right, Brian. I got into this litigation maybe a little longer, a few years before you, I think. And I was told I was only going to have a job for 4 or 5 years doing this, and that we were going to move on to something else, or this is going to end. And it has not happened, and that's because it's similar to the top. If you take away dosage as an issue, there's nothing you cannot, because if you take into consideration the fact that all of us right now are breathing in a certain amount of a toxic mineral, and the difference between getting sick and not getting sick is dosage, right? And so that exists. If you take away that mindset, that idea that dose matters, there is nothing that a plaintiff's firm won't bring if they can find the asbestos in the product. It doesn't matter. So once dose is relieved, talc is going to expand. I think the issue is if talc is going to expand to non-signature diseases, right? Meso is a ground ball for plaintiffs, right? It's a signature disease, they like to say, which is the language that's changed, related to asbestos. So it must be the talc because, quote unquote, they didn't get exposed to anything else, except for those few bankruptcy filings that they forgot to mention about. But notwithstanding that, it was the talc. So you have that to deal with. And what you have is an ever expanding realm of cancers that they want to apply it to. For example, the peritoneal cancer and cervical cancer and, and lower abdomen cancer. These cancers are opening up other avenues that were not normally never associated with asbestos. And through the talc exposures that they claim had asbestos, which is a whole other discussion. We can get into the geological discussion about where this comes from on another day.
I think that's episode.
But I can tell you now that I don't see us. If you moved, I grew up on baby powder. I think my mom, dried me pretty well. I don't think there's a person in this nation who did not use baby powder or some talc powder. Of course, as the litigation grows and companies are no longer viable for, they will stop saying those names and say the names of those that are viable. But, I don't see this ending so long as the system has decided that science should be democratized and let people decide what exactly did, what caused the disease. And I know we have a short break, but a short amount of time, but I just wanted to say, there was a recent case from New York that irritates me a little bit. It's the smoking lung cancer cases that have the ability to go to trial and blame asbestos exposure for a guy who smoked 2 packs a day for 60 years.
Right.
And they'll have an expert get up there and say, well, yes, cigarettes can contribute to the disease, but asbestos did too. And that doesn't sound like too much of an disagreeable statement. But then you have no markers, biological markers, to indicate that the exposure was of such a nature to cause lung cancer. Right. And I think, if you look at it that from a science perspective, those cases should not be allowed to go forth. At a minimum, there should be some sort of mark. But instead, we'll let the jury decide. I think, and then you have a jury recently, in terms of most recent cases, that, a jury found that, the cigarette smoking contributed to his disease, and he's at fault for maybe 25% of his lung cancer. And the defendant in the case was at fault for, let's say, 75%. But in addition to that, he deserves punitives for the disease he caused. And I think that's just, wait a minute, how could you give punitives to somebody if he self-induced his disease, even at 1%? he self-induced this disease, right? So how could you? It doesn't make sense to me. But that is for me, I think, what you see the litigation going to. You can self-induce a cancer with toxic, cancer sticks or whatever it is, and still get a chance to benefit from the idea of this ambiguous the ambiguity in the science between, was it the cigarettes or was it the asbestos?
Right.
You decide.
All I know is, all I can decide is I'm going to have you back on to talk about more of this, because I feel like we have literally just scratched the surface, but I'm already at that red light in the corner of my screen that says we got to get this wrapped up.
I can see that.
I really do appreciate your time, Gary. I am going to get you back on this because I've got a lot more questions, and like you said, this isn't going away anytime soon, so we'll have some time to talk more.
Sure, absolutely.
Thank you again for joining us. Thanks for telling us a little more about what you've got going, and we really appreciate it. And for everyone out there in podcast land, that is another episode of What's Cooking in Litigation. Thank you all for tuning in. If you found today's discussion helpful, please be sure to subscribe, like the podcast on your favorite apps, leave us a review, good, bad, or indifferent. It all helps. So until next time, take care and stay informed.
Thank you.
Thanks, Gary.
You've been tuning in to the Cook Group's podcast, What's Cooking in Litigation, with your host, Brian Wacker. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Thank you for sharing this show with others.